maritime. Maritime law regulates and enforces all maritime contracts. It does not take cognizance of agreements not in themselves maritime, although they may be preliminary to maritime contracts. So, too, the building of a ship is a maritime service, and the building contract is one with the cognizance of admiralty. But a mere undertaking to make a building contract for a ship or to procure a person to build a ship is not within the jurisdiction of admiralty, but maritime.
Okay.
It is not a maritime contract. It is not subject to regulation of the maritime law. The distinction in many cases will undoubtedly seem shadowy and unreal. Still, in a large class of cases, it will be readily perceived, and it's important, fully appreciated. And there's more to it,
right.
But that's one part of it.
All right, we're running over, and I'm going to let that happen. But because we are, I'm just giving you a heads up. All right, how does UCC fit in all this?
UCC is contract law. You have to have a contract with a particular party in order to go into a court with them. Now, in this admiralty, I'll read you.
Okay.
The Sixth Amendment is expressly limited to criminal prosecutions for crimes committed in some states or districts of the United States. The Seventh Amendment is limited to suits at common law, which does not include either suits of equity or of admiralty and maritime jurisdiction. So, that means that if you go in the Seventh Amendment and it comes right out and says so, the Seventh Amendment is common law and has no business in an admiralty court. Now, guess why? The court says you can't bring in the Seventh Amendment because it's $20 in common law suit, silver. There is no silver.
So in other words, since you don't have the means of transaction, you can't do it.
That's right.
Now, you could really get that, couldn't you?
Well, in the phrase suits at common law in the Seventh Amendment to the Constitution has also been made the foundation of the objection to the admiralty jurisdiction in all these cases, which in England, at the time of the Revolution, could not be tried in the court of admiralty, but it must be brought in the courts of common law, an objection which seems to have been first raised by the late Judge Baldwin in the case of Baines versus the schooner James and Catherine. All right, now remember, this was written in 1850. 1857, they bought admiralty inland, and no matter what contract you had, came under maritime jurisdiction. Therefore, admiralty court. By cases in law was meant the cases which legal rights and duties and offenses are to be ascertained in courts of law. By cases in equity, they are meant in cases which equitable rights and duties are to be ascertained in courts of equitable jurisdiction and proceeding. And by admiralty and maritime is meant which maritime rights, duties, and offenses became subject to the judicial cognizance in courts of admiralty and maritime jurisdiction. What is IRS? What is any revenue? Maritime, admiralty, jurisdiction.
Now, amongst these three, one is not, shall we say, more powerful or ubiquitous than the others, or is there?
No.
Okay.
No, it has to be a maritime contract. In other words, for admiralty court to sit, or the court to sit as admiralty. The court can pick and choose what it wants, and that's what it usually does.
And what about capital offenses, like murder?
Capital offenses in the United States was never given the court the jurisdiction for capital offenses. Okay. What they do is they took it and applied it like a capital offense, like in the two cases that I had cited in my New History of America, United States versus one Chevy pickup and one was a Ford, in that they started the case in admiralty and slid over to the civil side, which then everything became civil, even though it was criminal prosecution.
Well, we see cases where you have a criminal trial, and then, like with O.J. being high profile, then they go civil.
Yeah. But in this way, they can make the whole trial civil. In other words, they have to bring the Civil Rules of Procedure, Title 28, in, and they don't bring in Title 18, the criminal procedures.
So they morph right during the trial?
Yeah.
Does anybody tell the defendant's lawyer?
The defendant's lawyer knows it.
But it's a game he plays, too?
Yes.
All right, is there a point where he calls him to the bench and says, all right, we're doing it this way from here on in? Or in Dennis Chambers or something?
Well, let's put it this way. If you and I are mechanics, and we happen to go and be working on a car or something like that, we know exactly what we're supposed to do, huh?
Mm-hmm.
To get that car back, to run it.
Okay.
The owner doesn't know. Well, the same way in court.
Okay.
The owner doesn't know, but you and all your bar members know the procedures that has to take place during that trial.
Mm-hmm. Another dirty little secret on us, huh?
Yes. Yes.
All right. I'm going to bring it to a halt there. And, there's not enough I can say by way of thank you for coming on.
Okay.
I hope you appreciated it. I guess you indicated that you did, and I did right from the outset, and so did a whole lot of listeners. And
yeah, I think the last time I was on radio, a live radio show that I was happened to be was back in about 1992, 93. This is the last time I was on a radio show.
Well, welcome back.
Okay.
Check